Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 legislative changes to the TCPA. That, of course, is the Texas Citizens Participation Act. And if you know anything about the TCPA, you probably know that there were some amendments to it recently, and they go into effect on September 1st. So, what are the most important things the legislature changed? Let's get to it. Number 5, the amendments tighten up the definition of a legal action. That's important because to file a motion to dismiss under the TCPA, it has to be in response to a legal action. There was a lot of dispute over what a legal action included. One thing that the amendments do is to clarify that a motion filed in a lawsuit that does not add or amend a claim for relief is not a legal action. Number 4, the amendments clarify the deadlines for a response to a motion to dismiss under the TCPA. So now the statute says that you have to have at least 21 days notice of a hearing on a TCPA motion to dismiss, and the response to the motion has to be filed at least 7 days before the hearing. 21 days notice of a hearing, response 7 days before. Does that sound familiar? Of course, that's the same timeline that you have for a motion for summary judgment in Texas state court practice. And it makes sense because, in a sense, the TCPA motion to dismiss is kind of like a no evidence motion for summary judgment. The number 3 legislative change to the TCPA is that it tightens up the definition of the right of association. That's important because the right of association is one of the rights that gives you grounds to file a TCPA motion to dismiss. The previous definition was very broad. The new definition is a little narrower. It takes out the element of a communication. So a communication doesn't necessarily establish an association. It also says that the association has to relate to a governmental proceeding or a matter of public concern. So the right of association that would trigger a TCPA motion to dismiss is a little narrower. The number 2 legislative change to the TCPA is that it has a narrower definition of a matter of public concern. That's important because the previous definition was extremely broad. One of the things it included was that a communication about a good or service in the marketplace was considered a communication about a matter of public concern. The problem was that could include just about anything, and most Texas courts interpreted that definition literally. And so you could, as a result, file a TCPA motion in almost any kind of case. The new definition is a little narrower. It's still not clear to me what it's going to cover and what it's not going to cover. So take a look at that definition, and I expect we will continue to see litigation about just what that definition covers. And finally, the number 1 legislative change to the TCPA. This one is near and dear to my heart. The TCPA now carves out non-compete claims and trade secret claims. The TCPA will no longer apply to the typical non-compete or trade secret claim that you see in a departing employee lawsuit. That's important. The TCPA previously, as interpreted by Texas courts, could be used to file a motion to dismiss a claim based on a non-compete or based on the alleged misappropriation of trade secrets, but no more. that part of the TCPA is gone. They have taken the punch bowl away from the TCPA party. Those are the 5 most important legislative changes to the TCPA. It remains to be seen how they're going to play out in practice, but you can guarantee I'll be keeping an eye on that and maybe doing a future Top 5 Tuesday once we see how those changes are actually applied. I hope this update on the top 5 changes is helpful for you, and hey, thanks for watching.